Welcome back to the Legal Roundtable here on the Oscar Pistorius trial, a carte blanche channel. I'm joined in the studio now by tonight's legal experts. I have Advocate Mannie Witz, I've got former Zimbabwean High Court Judge Greenland, and I've got Defence Attorney Rudi Krause as well. Gentlemen, good evening to all three of you. Thank you for your time as we're about to go on our Easter break. And as we go to the Easter break, Rudi, let's just get an assessment from you of where we stand. When I look back at the week that's unfolded, possibly go into the previous week as well, we've seen Oscar Pistorius having a torrid time under cross-examination. We've seen Roger Dixon having a torrid time under cross-examination. I think there's a general sense that this is going very badly for the defence, for Oscar Pistorius at the moment. We do know that there are a substantial number of defence witnesses still to come to shore up the defence case. What's your assessment of where things stand at the moment? Who sleeps easier, state or defence, do you think?
Well, I'm not sure that any party would sleep easy at this stage. I think that the trial is still very much in the balance. The simple reason being that the state has set the bar fairly high. They want to persuade the court that they are going to prove that the accused committed this offence with premeditation. And I don't think that Harry has given up on that particular goal yet. So he's going for premeditated murder. The defence will obviously not sleep well. They're in the process of presenting their case. But all in all, I think that the case is at this stage still in the balance, especially in so far as the premeditation aspect is concerned.
And I'm loath to look at Mannie Witz and say, give me a view, because I know you're all bound by all sorts of rules of this. I realise, Chris, I sometimes liken this to a cricket match, and at the risk of oversimplifying, if it's a test match, you can never say until you're really at the final stages who's winning and who's losing a game of cricket. To what extent is that true of law as well? You've really got to wait until all the witnesses have had their say before you can make an assessment.
I think that the fact of the matter is that this particular case is extremely exciting for any number of reasons which have been stated eloquently. And as regards the merits, it's exciting because everybody already knows who killed who.
Yes.
It's simply the why.
Yes. And
it's at all the other attributes of a good theatre, and court cases are theatre. So the public are involved. The people are induced, prompted, tempted into having opinions, and we're seeing those opinions, and it's understandable.
Yes.
And I think it's healthy. What I'll say to the public is this, in terms of my over 35 years of experience in court. When you are most sure, be most careful. I could spend the rest of the evening giving you anecdotes to prove this. So I'd say, yes, get involved, have your opinions. It is good. But when you're most sure, be most careful.
Yeah. Mannie, you can make a comment on that, I'm sure.
Yeah, no, definitely. I can definitely make a comment on that. Look, I think really at the end of the day, look at the totality of the evidence and have a look. If there's screaming and shouting and the court accepts that before the shooting, then the defence have got certain difficulties to overcome. If not, and he sticks, and his version sticks that it was a mistake, if it's a mistake, negligence, no intention, then you're looking possibly at culpable homicide, possibly on that basis. That's the way I think the defence would obviously be looking at this stage of the matter.
Well, I enjoyed the way Greenland has distilled this down to the essentials of we know who shot whom, it's the why. If that's really what this is about, why are we having all the evidence about the way in which Reva fell? Was it against a magazine rack, or wasn't it? Which shot was first, which wound was first? Why do we need that evidence?
No, you definitely need that. You need the ballistics and you need the forensics.
How's that helping the why?
It helps the why very, very simply, because if you can show position, if you can show which was the first shot, if you can show which shot actually killed on the A, B, C, D and the ricochet, etc., what you then get when you weigh that up with the circumstantial evidence and the factual evidence of what Mr. Pistorius, the accused himself, has said as to his position, where he was, when he fired, when the shots went, that helps you to work out intentional, unintentional, mistake, not a mistake. That's really what it's about.
I thought one of the telling things that Gerrie Nel said in his cross-examination is he referred to Riva falling as a result of the hip injury, and then he said, and then you tracked her as she fell. That obviously is something that he wants to use to show murderous intent, isn't it?
Yes. I think what's important here is that Oscar is the only person that knows why she was shot.
Yes.
So all this other evidence is actually to match up, to test whether what he is saying is actually true.
And reasonably possibly true, isn't it?
Well, yes, I've heard this being served up time and time again.
By the prosecutor?
By us in the legal profession. And that's the legal label we've given it.
Yes.
But in reality, it's as simple as this. The judge has got to believe him for him to be acquitted. That's what it means. Oscar has to impress that court sufficiently to get the court to believe his story. If the court does not believe his story, then he's going to be convicted.
Okay, the way I understood it, and this is coming from other legal experts that have been on the panel, is that it may be an unbelievable story, yes, but as long as it's possibly true, and further than that, reasonably possibly true. And I'm really battling to get my head around these concepts. Really, can you shine some light on it for me?
Well, Mannie used the term circumstantial evidence. There is no direct evidence other than, as Krause has pointed out, the accused himself. So the state's case is based on a certain interpretation of the circumstantial evidence and the circumstantial factors. So what the prosecutor would typically want to do is, when all the evidence has been led, ask the court to draw certain inferences from the evidence that has been led. And that is why the prosecutor has been putting certain versions to the accused, especially during the course of cross-examination. And the prosecutor will seek to persuade the court that the inferences that he wants the court to draw are not only reasonable inferences, but it is the only reasonable inference to draw from those certain or the specific pieces of evidence, excluding all other possibilities.
Yeah, excluding all others. That's
the acid test.
Okay.
And can I just come in here? What the state is going to argue about Oscar's story is that it's implausible and irrational, and for that reason, Oscar should be disbelieved. So just to correct what I previously said, that the judge has got to believe him. What I should have said is that if he is disbelieved, he will be convicted.
Okay. Yeah. Do you want to add anything to that, Mannie?
Yes, I think what you've got to add in, I think, is a very important aspect that the viewers need to know about this case. He's given his evidence. He's been thoroughly and properly cross-examined. Very testing cross-examination, thorough and grueling at times. You've got to have a look at his state of mind at just past 3 o'clock on the fateful morning. What was going through his mind? What did he think? And how does he react? Him, as the accused in this matter, under pressure. What is his reaction under pressure? And I've got no doubt, if I was defending and if this is the defense, go get a good psychiatrist, get a good psychologist, get inside the person's head, get inside his mind, say that's how he reacted, that's why he reacted, he's lived his certain life in a certain way with disabilities, etc. And you've now got to look at him a little bit careful. And are those the actions of the reasonable man or the reasonable woman in that position? How would they have reacted? Would they have gone towards the danger? Would they have kept away from the danger? Would they have gone down the stairs? And I think Rudi is 110% correct what he told the viewers. Gerrie is trying to cover all those aspects to show you could have done this, you should have done this, that's what could have happened, and that's why it's improbable. So really, from our point of view, I think that's really what you have to check, and that's what you have to verify and see in those circumstances. Is that reasonably possibly true the way you acted?
Okay, well, it goes to the why as well, and I'm going to ask you a couple of more questions about the way that is explored. We'll also look at the way in which an expert's witness is assessed, and I'm looking particularly at you, Judge, to tell me how you would anticipate, how you would approach this when you've got two expert witnesses giving you different conclusions. That's all coming up. You can join us on Twitter, Facebook, Instagram, and WeChat by searching for Oscar Trial 199, and a little later in the show we'll have a look at the tweets that you sent to our legal panel. I'll be back with the panel after the break.